In this video, I'll address the key legislation that applies to the federal government, its agencies, and in some instances, contractors. These 9 acts shown in the boxes are listed from earliest to most recent. They'll be covered in summary format indicating who they apply to, the provisions and compliance requirements. The websites where the full act can be found will be provided where applicable. The Office of Workers' Compensation Programs administers 4 major disability compensation programs, which provides wage replacement benefits, medical treatment, vocational rehabilitation, and other benefits to certain workers or their dependents who experience work-related injuries or occupational disease. Federal Employees Compensation Act of 1916. The Federal Employees Compensation Act provides workers' compensation coverage to approximately 2.6 million federal and postal workers around the world for employment-related injuries and occupational diseases. The Division of Federal Employees Compensation has responsibility for administering the Act through its 12 district offices and national office. Longshore and Harbor Workers' Compensation Act of 1927. The mission of the Act is to minimize the impact of land-based marine employment injuries and deaths on injured employees and their families by ensuring that workers' compensation benefits are provided promptly and properly under the laws that apply. Benefits paid under the Act and its extensions total $1.1 billion in calendar year 2018. The role of the Act is to provide technical assistance, dispute resolution services, and oversee benefits delivery by the self-insured employers and insurance carriers it authorizes and regulates. Black Lung Benefits Act of 1969. The Division of Coal Mine Workers' Compensation, or Federal Black Lung Program, administers claims filed under the Black Lung Benefits Act. The Act provides compensation to coal miners who are totally disabled by pneumoconiosis arising out of coal mine employment and to survivors of coal miners whose deaths are attributable to the disease. The Act also provides eligible miners with medical coverage for the treatment of lung diseases that are related. Energy Employees Occupational Illness Compensation Program Act of 2000. The Act compensates current or former employees or their survivors of the Department of Energy, its predecessor agencies, and certain vendors, contractors, and subcontractors who were diagnosed with a radiogenic cancer, diseases as a result of exposure to radiation, beryllium, or silica while employed at covered facilities. The Rehabilitation Act of 1973 prohibits discrimination on the basis of disability in programs conducted by federal agencies, in programs receiving federal financial assistance, in federal employment, and in employment practices of federal contractors. The standards for determining employment discrimination under the Act are the same as those used in Title I of ADA. It protects qualified individuals with disabilities. An individual with a disability is a person who has a physical or mental impairment that substantially limits one or more of life's major activities, has a record of such impairment, or is regarded as having such an impairment. Qualified means the person satisfies the job-related requirements of the position he or she holds or is applying for and can perform its essential functions with or without reasonable accommodation. This replaced the Vocational Rehabilitation Act and created support for states to create vocational rehabilitation programs. The original term used in the legislation was handicapped. The law was later modified to replace that term with disabled. The Privacy Act of 1974 was passed to protect the privacy of individuals employed in government agencies or by government contractors. This act prohibits an agency from disclosing records about individuals. While the Privacy Act restricts what government agencies can release, The Freedom of Information Act requires government agencies to provide information about the agency, how it's organized, and what it does, and allows individuals, employers, and unions to request copies of the government's documents. However, the Freedom of Information Act specifically exempts disclosure of personal information that could constitute an unwarranted invasion of personal privacy, such as performance evaluation and medical reports. Under the Privacy Act of 1974, a Privacy Protection Study Commission was established to examine the need for further legal protection of employee privacy. The Commission conducted extensive hearings on the problems of employee privacy and submitted a massive report. It recognized a fine line between protecting employees from unwanted invasions of privacy and the employer's interest in being able to make informed decisions. As a result of its hearings, the Commission established 3 general policy goals: to minimize intrusiveness, to maximize fairness, and to create legitimate expectation of confidentiality. The Civil Service Reform Act of 1978 reformed the civil service of the United States federal government, partly in response to the Watergate scandal. The act abolished the U.S. Civil Service Commission and distributed its functions primarily among 3 new agencies to take its place. The Office of Personnel Management, OPM. This is the executive branch's Human Resources Department. It handles all HR issues for agencies reporting to the U.S. President. The Merit System Protection Board, MSPB. This part of the law prohibits consideration of marital status, political activity, or political affiliation in dealing with federal civilian employees. It also created the Office of Special Counsel, which accepts employee complaints and investigates and resolves them. The Federal Labor Relations Authority, FLRA. This is the agency that enforces federal civilian employee rights to inform unions and bargain with their agencies. It establishes standards of behavior for union officers, and these standards are enforced by the Office of Labor Management Standards in the U.S. Department of Labor. Federal employees are protected by the Whistleblower Protection Act of 1989 if they disclose information that they reasonably believe is evidence of a violation of any law, rule, or regulation, or gross mismanagement, a gross waste of funds, an abuse of authority, or a substantial and significant danger to public health or safety. Whistleblower laws usually apply to public sector employees and employees of organizations contracting with the federal or state governments. Construction projects not being built to specification can result in whistleblowing by government employees. The Act allows for federal employees who believe they have been subjected to reprisal because of their protected disclosures to seek protection and will be made whole by remedies available under the new law. The Congressional Accountability Act of 1995. The Congressional Accountability Act of 1995 is the first piece of legislation passed by the 104th United States Congress. It applied several civil rights, labor, and workplace safety and health laws to the United States Congress and its associated agencies, requiring them to follow many of the same employment and workplace safety laws applied to businesses and the federal government. Previously, agencies in the legislative branch had been exempt from these laws. The Act also established a dispute resolution procedure as an alternative to filing claims in federal court. The Act is administered and enforced by the United States Congress Office of Compliance. The law requires Congress and its affiliated agencies to abide by 12 specific laws that already apply to other employers in and out of the government. This table shows the legislation organized by the number of employees each agency will be required to have for the law to take effect. The Act extends the rights to an additional 30,000 employees in the legislative branch.